and now all of a sudden he's an adult and will be treated as an adult. I never understood how that worked. I mean,
well, I guess when you're a juvenile, I guess there are two ways to look at it. As a juvenile, you're so young, you shouldn't be in jail, and jail is not going to have the rehabilitative effect it may have as an adult. But long and short of it is he committed the crime as a juvenile and is being punished as an adult. He didn't commit the crime as an adult.
And
so
see,
how that works.
But that's an example of the political correctness that I'm talking about. And what that clearly is, you have African American and Latino kids all across the country that are age 13, 15, they're tried as adults, and maybe they should be. So with the public sentiment, how could you try these kids of color as adults?
Because the law also changed, to be fair to you. At the time, the law was this: if the same crime was committed, you know, in '92 or whatever it was, the law had changed since that point from the mid-'70s to '92 that said, no, if he committed it today, this is how it would have worked here. It just always, to me, from the layman's perspective, just seemed a little double jeopardy. But let me get to the other two remaining questions. One is Mickey Sherman. Like I said, Mickey came on the show all the time. He talked about the case. I know it's part of an attorney's job here to shape public opinion on this. But that said, where is the line between getting yourself out in front of the camera and then doing your client more harm than good?
The line is you don't even go close to the line when it approaches doing your client harm. I don't think that that's the situation here. I think that as much, look, it drew so much publicity. It was going to happen. There was going to be interviews. That's not what the problem was, according to this judge. According to the now whether or not the publicity disenabled him from doing the investigation that the court should have been done, or raising the defense that should have been done. 20 years later
for it to come up? Have you ever heard of something like this?
For the prosecution to come up?
No, 20 years later, after the guy went away, that now 20 years later, counsel's effectiveness on, it's not like this happened in, you know, the middle of nowhere, Arkansas. This was on national TV every day, the trial. Yeah, that now all of a sudden, the counsel was insufficient here for the client.
Because what the ineffectiveness is in what wasn't done. What's not there, you can't see. It takes time to investigate that. For example, what
20
the court,
years?
well, it was, well, the conviction was when?
92.
The conviction?
Yeah. He went away, the crime happened in 75.
And he went away in 92.
He did it in 92. It's been 20 years.
What they did was they
found
found witnesses that if the witnesses were called, they would have debunked Coleman's testimony. The stuff on Thomas Skakel, I mean, I agree with you. So much of that was out there. It was corroborated by the forensics. His lack of candor when he first spoke to the police, then he comes forward. I suppose through the entire appellate process, which took several years, and mind you, one of the appeals is what precipitated this motion, because they made an appeal to the court saying, we have new evidence. The court actually responded and said, we're denying your appeal. Your attorney could have figured this out and raised it during the trial. So when the appellate court says your attorney could have done it,
that it wasn't sufficient counsel from what you've seen.
What this court found, I do. Look, you've got a 25-year-old conviction based on what everybody can agree was pretty flimsy evidence, and you've got witnesses who are debunking the very witnesses who put words in Skakel's mouth.
I got to get out. Do you think he's going to get out here? That he's going to be released, and if there's a new trial, he's going to show up in a suit instead of walking out from a jail cell?
I think he should. The conviction has been vacated. I understand the argument that convicted murderers aren't entitled to bail. He's no longer a convicted murderer from my perspective. The judgment has been vacated. He is now in the shoes he was before that jury was picked and he went to trial. He wasn't a flight risk back then. He's done 20 years. He should get released on the same bail and go on to trial. Why should he serve another day if he's going to get acquitted again?
Fascinating case. It raises so many interesting questions. James, thank you so much.
My pleasure.
All right, Don, my friend, we're going to jump to a break here. When we come back, we will switch gears. Talked about a lot of tough stories. When we come back, we got a heartwarming video about surviving cancer in honor of Breast Cancer Awareness Month here. We're going to show you a clip here that hopefully will get you to click and vote for the folks you're about to see. Stay with us.